Good morning. My name is Mateusz Fałkowski. I'm deputy head of the Pilecki-Institute here in Berlin. I wanted to extend a warm welcome to everybody at our event, our lecture with Ambassador van Schaack, holding Russian kleptocrats and human rights violators accountable for their crimes against Ukraine. I wanted to extend a warm welcome to the members of Polish Parliament with the chairman of the Culture Committee, Piotr Babinets. His Excellency Ambassador Dariusz Pawłoś, representatives of the American Embassy, and our special guest, Ambassador at Large, Dr. Beth van Schaack. I also want to welcome Professor Magdalena Gawin, the director of the Pilecki-Institute in Warsaw, and, even more importantly, the director of the Lemkin Center. Now I would like to say some words about the spatial context we see today. This exhibition you see here is about war crimes against the civilian population of Warsaw in 1944. And the lack of accountability for these crimes after the war, after 1945. When the perpetrator of the deaths of about 58,000 residents of Warsaw was able to pursue a political career and career as a lawyer. This reflection on the unpunished crimes of the Second World War was and is an impetus for us to think and act in the context of Russia's aggression against Ukraine. And exactly in 1944, there was the underground group around the historian Edward Serwański who started to collect testimonies from civilian survivors of the Wola massacre in Warsaw. And now these collections, these archives, these testimonies of civilian inhabitants of Warsaw, are available in the archives. So about 300 testimonies are still available. And this is our point of departure, to think and act about the accountability now in the context of the war of aggression of Russia against Ukraine. But there are also the question about the points of destination, about destination points. And of course, we can think about this collection of testimonies for advocacy efforts. Secondly, we can think about it for evidence in court or criminal accountability. Finally, we can also think about it for ongoing and future research, and also for future generations and collective memory. And of course, collecting testimonies for criminal accountability is something different from collecting testimonies for collective memory. But both are very important for social sense of justice, cohesion, and remembrance. And we learned this lesson from the Second World War, and we want to have these lessons and this knowledge present also in the context of challenges we see today. And now I want to invite you to the lecture by Ambassador van Schaack and pass the microphone to Nora Müller of Kerber Stiftung, who will be moderating our event. Nora, the floor is yours, please.
Mateusz, thank you very much, and a very warm welcome to all of you. You know, when I went through this harrowing exhibition about the German war criminal Heinz Reinefahrt here, kind of one thing kept coming to my mind, and that is there is only one thing worse than a crime, and that's a crime unpunished. And it seems to me that this could also be the leitmotif of Ambassador van Schaak's professional career. Before I turn it over to you, Ambassador, let me say a quick words of introduction about your impressive career. You are an attorney at law and also a legal scholar. And Ambassador van Schaack assumed her current position as U.S. Ambassador at Large for Global Criminal Justice less than a month after Russia's reinvasion of Ukraine. She once said of herself, that she was not destined to go into law. Actually, she started out her professional career as a expert in public health, and then, as I understood it, Ambassador, you went to Kenya and came back with a huge interest in human rights issues, and all the rest is history, so to speak. So just to mention a few of your professional stints: Harvard Law School, Morrison and Foerster LLP, and also the Office of the Prosecutor of the International Tribunal for Yugoslavia and also for Rwanda. So, Ambassador, it's fantastic to have you with us. Without further ado, as they say, please take the stage.
Good morning, everyone. It's really quite wonderful to be here in Berlin, which I last visited in 1989. I was a student studying abroad in France, and the wall had just come down, and we all felt like we had to come and do a pilgrimage. And so we came across and did our part to take the wall down, and I still have a little tiny piece of it somewhere in a drawer somewhere at home. It's also very special to be here in this place within Berlin, in the shadow of the Brandenburg Gate, which of course reminds us that history is long and that change can happen. And it's only by virtue of the work of all of us that that change can happen. And it's quite special to be here in this institute. I've been learning a little bit about the history of the institute and the important work that you do, keeping, as you said, Mateusz, memories alive, continuing to tell the story as more and more information over the years continues to emerge. And so, again, we are playing, I think, all of us, a long game here when it comes to justice and accountability. And that will be equally as true for the situation in Ukraine. I will use my remarks, I think, to speak about several pathways to justice and the role that not just the United States, but the very strong transatlantic partnership is playing in advancing all of those pathways to justice. We know, of course, that Russia's actions are a manifest violation of the United Nations Charter. This violation began in 2014, but was intensified more than a year ago now in February 2022 with the full-scale invasion of Ukraine. This is a war of aggression that is being committed through the perpetration of war crimes and crimes against humanity and other atrocities virtually everywhere that Russia's troops are deployed across the territory of Ukraine. The United States approach and the approach of friends and allies around the world towards the war in Ukraine has three main pillars. The first is strengthening Ukraine's hand on the battlefield so that it is in a strong position at the negotiating table. Number two, addressing the critical humanitarian crisis. We know that the epicenter of suffering is in Ukraine, but the reverberations of this war of aggression are global in the form of food insecurity around the world, supply chains disrupted, dis and misinformation traveling much faster than the truth can travel. So the second pillar is dealing with these humanitarian concerns. And then the third pillar, of course, is justice and accountability. And that is where my office, the Office of Global Justice, comes in. We are working to advance 5 pathways to justice. The first involves strengthening Ukrainian courts and processes. Ukraine will be the front line of justice here. The majority of cases will happen in Ukrainian courts. The Ukrainian prosecutor has now registered more than 80,000 potential war crimes and other atrocities. This would be a daunting task for even the most well-resourced prosecutorial office. Imagine having to sift through 80,000 potential incidents, determining how to prioritize those prosecutions, gathering sufficient evidence, identifying responsible individuals, not just the direct perpetrator, but those up the chain of command, marshaling the resources, and then doing all of that in the context of a hot conflict where your investigators and prosecutors are constantly having to go into bunkers when air raid sirens go off above them, constantly having to work in the field that has been littered with mines, with improvised explosive devices, including children's toys being mined by the Russians as they depart areas that had previously been under their control or occupation. So it's an incredible challenge. The United States has partnered with the European Union and the United Kingdom to launch what we are calling the Atrocity Crimes Advisory Group. This is a multinational effort to assist the Prosecutor General in his efforts to prosecute these crimes under Ukrainian law in Ukrainian courts. We are deploying experts from the world's war crimes tribunals and national systems who have done war crimes and other atrocity prosecutions in their own courts. So, for example, individuals who may have worked on the siege of Sarajevo before the International Criminal Tribunal for the former Yugoslavia are now working with Ukrainian investigators and prosecutors who are investigating the siege of Mariupol. What kind of evidence is necessary? How do you overcome defenses? How do you potentially work with insider witnesses? How do you approach victims and survivors in a trauma-informed way so you don't re-traumatize them through the context of interviewing them for a criminal investigation? These are all the types of things that the Atrocity Crimes Advisory Group is assisting with. So that's pathway number one. That's the primary pathway to justice. Pathway number two involves international institutions. And the United Nations quickly launched a commission of inquiry that is continuing to investigate the situation, creating very detailed reports that can be shared with prosecutors and investigators. The OSCE has now three times invoked the Moscow mechanism, focused investigations on violations of the core principles of the OSCE. And then, of course, the International Criminal Court. It received an unprecedented referral by 43 states parties asking the ICC to go forward with an investigation. The prosecutor responded immediately, has now opened a field mission in Ukraine, has deployed a number of investigators there, and has made his first move, asking for an arrest warrant for President Putin himself and for his Children's Rights Commissioner, Maria Lvova-Belova. The subject matter of that arrest warrant is the abduction, the deportation of children across an international border and having them be deported often very far into Russia. This is a grave breach of the 1949 Geneva Conventions, and much of the evidence that will be used to prosecute this case comes from the mouths of the defendants themselves. As we know, Russia has bragged about the process of taking these children and subjecting them to adoptions within Russia. And so all of that information can be part of the file that the International Criminal Court is looking at. So that's pathway number two, international institutions. Pathway number three involves courts in third states that might be able to exercise extraterritorial jurisdiction over the commission of international crimes. Germany, in many respects, has been the lead here. Germany has developed a very strong practice of prosecuting international crimes in domestic German courts, mostly emerging from the wars in Iraq and in Syria. A number of Syrian perpetrators have managed to find their way here to Germany, often under false identities. They have been identified by members of the diaspora, refugees, and others who are here. Because of a trusted relationship between refugee populations and law enforcement, that information comes to the attention of prosecutors, and those cases have moved forward. There have been cases involving foreign fighters who have gone to the battlefield, but also very high-level regime figures who have found their way here. That model of working closely with diaspora communities, with civil society organizations, with others to identify perpetrators, witnesses, to accompany survivors through a justice process can be replicated when it comes to the situation in Ukraine. European prosecutors are increasingly interlinked under the umbrella of the Eurojust network sitting in The Hague. They are working together to share information, to share strategies. They've created a shared database. Their prosecutors are working together directly. They've created a joint investigative team among some of the frontline states within Europe. Poland is a member of that team. That makes it somewhat more frictionless for prosecutors to speak directly with each other without the need to go through complicated diplomatic processes. All of this will enable European states to move quickly if and when a perpetrator is found within their midst. Many European states have enacted statutes that allow for the extraterritorial jurisdiction over international crimes, regardless of the nationality of the perpetrator or the nationality of the victim or the place of commission. And so this system now has been strengthened by the war in Ukraine. Fourth pathway to justice involves my own courts. we have been advocating for Congress to strengthen our own legal framework and to mirror that which we see in Germany and some of our close NATO, G7, and other allies. Just last year, at the end of the congressional term, Congress amended significantly our War Crimes Act. It had originally been drafted to require that the perpetrator or the victim be a U.S. person. So there may be some cases of dual nationality or American journalists that have been injured within the war in Ukraine, but it was likely not going to be the basis for expansive prosecutions. Congress has now eliminated that requirement so long as the defendant, the accused, is present in the United States. U.S. courts now have jurisdiction. Our Department of Justice has created a war crimes accountability team, the WarCat, which is singularly focused on investigating potential cases emerging from the war in Ukraine. So that's pathway number 4. The final pathway to justice involves the crime of aggression itself, what Ukraine has called the original crime, the crime that without which none of the other crimes would have happened. There is at present a jurisdictional gap in our system of international justice. The International Criminal Court does not have jurisdiction over the crime of aggression committed in Ukraine. I'm happy to discuss that during the Q&A if people are interested in understanding how we have arrived at that point, but that is the reality. And so Ukraine has conceptualized a standalone, dedicated tribunal to prosecute this singular crime. We are now engaged in a series of multilateral conversations with peace-loving states around the world to conceptualize what that tribunal might look like. The United States favors an internationalized tribunal that would be deeply rooted within the Ukrainian national system. It would benefit from significant international assistance in the form of personnel, experts who could be seconded to this institution, in the form of information sharing, so evidence that might be gathered by individual states could be shared with the prosecutors within this tribunal for the purposes of bringing cases, diplomatic support, funding, a whole range of ways that the international community can support this internationalized tribunal. It could sit during the war extraterritorially. The Netherlands, which is the international seat of justice, where the International Criminal Court is, the International Court of Justice, they have offered to host this institution, maybe temporarily, before it can then be moved back into Kyiv or into Ukraine in order to finish its work. This model, we believe, has the best potential to maximize accountability for the crime of aggression. It also is consistent with international law and the UN Charter system. It also enables a strong amount of international support. There is precedent for creating these types of internationalized tribunal. They have been very effective around the globe. And it offers a possibility to marshal international resources that are already quite overstretched, as we know, particularly in responding to multiple planetary crises, but also the crisis within Ukraine. And so where these conversations are continuing even now as we speak, the Council of Europe will be considering this model, and other conversations are happening around the globe. So with that, I'd like to close. These 5 pathways are underway. The international community has rarely been this united around the imperative of justice, and have rarely been able to speak so strongly with one voice about the need to provide justice to ensure not only accountability for this particular crime, but to also send a message to other states that might be emboldened by a situation of impunity, that are watching closely to see how the international community responds to this situation, in order to send a message that the world will respond robustly if and when states breach not only international peace and security and the precious principles underlying the UN Charter, territorial integrity, political independence, the right of all of us to live a life of peace, but also breach international norms around the law of war and the way in which wars must be waged, where civilians are entitled to protection and where accountability must follow breaches. So with that, again, I'm so pleased to be here. It's a real honor to be asked to come and give this lecture, and I really look forward to our conversation and to questions from you all. So thank you.
Ambassador, thank you very much. That was a super interesting introduction. And I wanted us, for starters, to go to Reykjavik, in fact. Reykjavik is the place where the leaders of the Council of Europe are meeting as we speak, and the issue of justice, of accountability, is really top of their agenda as well. And I think one issue under discussion is the issue of a register for damages caused by Russia's reinvasion into Ukraine. So I think the US has endorsed this idea. I think Ambassador Thomas Greenfield is also on site in Reykjavik. So what do you think, how important is this issue? Is it a significant step forward when we talk about accountability and justice around the war in Ukraine?
Yes, it's an extremely important initiative. This has its origins in a General Assembly resolution some while back, where the General Assembly welcomed the consideration of a claims registry. The theory being that there has been massive destruction across all parts of Ukraine. We've all seen those photographs in the news and in the newspapers of entire cities leveled, of precious cultural property destroyed, of schools, of hospitals, etc. But also ordinary people's lives disrupted, their homes destroyed, their belongings, and then also physical harm to themselves, to their loved ones. And so the idea was to create a registry of individualized damages, where ordinary Ukrainians, Ukrainian small businesses, etc., can register the losses, and the goal would then be to eventually create a claims commission such that when funds are made available, those funds could be deployed in order to compensate individuals who have experienced losses during the war. We have had in the past examples of these claims commissions. So in the Iran, the first Gulf War, if you remember, Iraq was subjected to a claims commission to reimburse Kuwait for some of the damages that had happened. In the Eritrea-Ethiopia war, there was an arbitration process that resulted in war claims being paid. So these are some of the precedents that are being considered here. So the next step would be for the creation of the actual commission. Probably it appears under the rubric of the Council of Europe, likely based in the Netherlands, but would be under the Council of Europe. And there's a special provision that the Council of Europe can utilize to expand participation even beyond members. So the United States will be in a position to partner with this effort and to be a part of the creation of this claims commission.
Right, so this is a significant step forward. You once spoke of a Nuremberg moment, looking at, what the war has done to sort of a re-energized conversation about the importance of international criminal law as well. And I found that interesting. When we look at the situation and when we compare it, though, to defeated Germany after World War II, then I think one important difference is that Putin's Russia, is unfortunately not defeated yet. And Putin and his clique are well entrenched, don't seem to be willing to surrender anytime soon. So in light of what you said about the Nuremberg moment, what would you say, how likely is it really that Putin will be able to be taken to court at whatever point?
It's, of course, the million-dollar question, right? We have no international police force that can go and arrest him across a sovereign border. So as long as he stays within Russia, he will enjoy some measure of impunity. Now, that said, there have been incredible responses in terms of sanctions, in terms of his ability to travel freely, right? All of these have been significantly constrained by virtue of this war. So he's experiencing serious personal consequences to his decision to launch this war. But he's not in custody. He's not having to face charges directly yet. However, if you recall, Slobodan Milosevic or Augusto Pinochet or Hissène Habré of Chad, none of those men thought they would ever see the inside of a courtroom, and each one of them did, ultimately. And so, as I mentioned earlier, we are all playing a very long game here. If and when this war comes to an end, which of course we know it must, all wars do eventually, if and when it comes to an end, the question is, will there be some kind of political transformation within Russia? will the Russian people or Russian leadership realize that Putin has led them down a terrible strategic error that has left Russia essentially a pariah state within the globe? And so will high-level members of his cabinet and others realize that they're safer outside Russia than they are inside Russia? And so will there be a decision of some of them to leave, and then will he be tossed out at some point? We can't speculate. This is all for the Russian people to decide ultimately. But the key now is to lay the groundwork, and that is being done in terms of documentation of abuses, in terms of building an infrastructure, building the institutions that can deliver justice, preparing prosecutors, preparing dossiers, having charges be ready so that we can move collectively, quickly, once a perpetrator, whether it's Putin himself or someone down the chain of command, or a very low-level perpetrator, when they come within the jurisdictional reach of a court that's able to move forward. And that's the groundwork that is being laid now in an increasingly and a really impressive scale, degree of coordination across the transatlantic system, but also with a lot of support around the globe.
Right. You mentioned that we're playing the long game here, and that is certainly true. So let's imagine, as you said, if and when there are, peace negotiations with Russia, don't you think that Russia might be likely in such a scenario to demand release of criminal or from criminal liability as part of whatever settlement is negotiated at the end? So isn't that an argument against such a tribunal?
Obviously, he's entitled to make that argument, but many states are under solid international law and domestic law obligations to pursue accountability in the face of international crimes. So it's not for anyone to give that away. Those obligations exist and will remain in place regardless of what sort of a peace arrangement is undertaken.
But won't that make diplomacy much harder?
Well, we saw this in the former Yugoslavia, right? We found a way to undertake the Dayton Peace Accords and to isolate those individuals who would be spoilers to peace. And so that is the same approach that will have to be taken here. There will have to be a way in order to continue the promises of justice, which are part of international law now. They cannot be simply dispensed with, while at the same time encouraging Russia to approach any sort of peace negotiations from a spirit of genuine of genuineness and sincerity. And frankly, we haven't seen that. There are no ongoing, active, genuine peace negotiations. We cannot expect Ukraine to arrive at a peace deal that involves ceding large swaths of its territory to Russia. We have seen what happens to individuals under Russian control and occupation, right? When the Russian forces withdraw, we find clandestine torture cells. We find women who testify to multiple acts of rape at the hands of Russian citizens. We find looting. We find the destruction of the civilian infrastructure. So this is the fate of Ukrainian citizens if they're left under the control or occupation of Russia. And so Russia needs to come forward with a realistic plan to cease hostilities and to relinquish the territory that it has seized.
Yeah, and I think we would all subscribe to that. But again, let me sort of press you a bit on the issue of international legitimacy, a difficult word, for whatever tribunal there's going to be. So I think there is a large consensus in the Euro-Atlantic world that this is a good idea. Thank you, Mateusz. But what about the countries in the global South? So first of all, I don't think many of them really like the idea of picking sides. That's one. And then the second point is that they also oftentimes speak about politicized justice. So these are some of the counter-arguments that are put forward by the countries in the so-called global South. So how do you deal with that? Also in forging a sort of a comprehensive alliance of states that might support whatever form of tribunal there's going to be eventually.
Yeah, we have to be very alive to those concerns. They're absolutely true, they're out there, and we need to be able to address them. I do think that many states feel somewhat squeezed. We see Russia out there traveling to Africa and elsewhere, trying to shore up support using trade and other mechanisms to do that. And we need to be able to outcompete Russia in that regard and to show that being a part of the circle of democracies is ultimately a better place to be. It's more prosperous. There's more freedom. Your people will do better doing trade with the West and with the United States and with other states rather than selling yourself down to what Russia is offering and others. So that's I think a key point. I think it's also really important to emphasize the core principles and values that are at stake. Territorial integrity, political independence. These are principles that are enshrined within the UN Charter and that the so-called Global South cares deeply about in a post-colonial context. They have to see that what this is, in essence, is a previous colonial power attempting to take back in an imperial way, a former colony. That is the model. That is what is happening here. And so I think when I speak, and I am the ambassador at large for global criminal justice, so I do travel the world in my role. I've been to Africa twice, I've been to Latin America twice, I've been to Asia. And the conversations I have is what I hear is a high degree of empathy amongst these states and individuals, the press, ordinary people, for what the Ukrainian people are experiencing. At the same time, they are disappointed that the international community did not respond with the same degree of unity and vigor that they have responded now. And we have to acknowledge that sense of selective justice. We have to recognize that we have fallen short as an international community, and we have to find ways to build a system that will be more universal so that when other states are experiencing terrible atrocities, the international community responds with the same degree, to the same degree that it has in this particular conflict. I think what we are doing is we are putting in place a stronger, more robust architecture that will apply broadly to other situations. We are developing techniques for doing open source investigations, which we will be able to deploy in other places around the world. We're strengthening the International Criminal Court. We're strengthening the system of extraterritorial jurisdiction. We're strengthening national systems. We're building confidence within war crimes units that they can do these cases and they can do them successfully. All of this, I think, will redound to the benefit of the entire international community when other states, unfortunately, we fear will have similar experiences in Central Africa, for example, with the M23 militia movement in the DRC or other places where we see violations happening.
Interesting you're saying that. I think my view of things would be a little less sort of optimistic. When I speak with interlocutors from the Global South, I oftentimes sense a great degree of frustration in the sense that, the West, is just ring-fencing itself by putting up those courts, and why isn't it that, Western states are put to trial, and it's always us in the Global South. So what often, emerges is the issue of double standards. So do you think we address these issues in the right way?
Well, I guess I would fall back on my earlier answer. It's a constant challenge, and it's something we need to keep working hard at to build those bridges. I think it does help to show what the Ukrainian people are experiencing and identify parallels in the experience of other states. So we know in Latin America there was a strong practice of stealing children of women or families in detention, giving them to other families that were aligned with the regime in power at the time, having their identities be completely erased. And even today, those children, who are now, of course, fully grown, have learned what have happened to them, and they're desperately trying to find their birth families. And we've seen these incredible reunions now, decades later. So that is something that I think states of the Southern Cone can see and recognize, and it will resonate with them when they're imagining what is being experienced by Ukrainian families whose children have been taken. I think we have to start identifying those parallels in our own experiences with violence. And then again, it's about acknowledging where missteps have been taken, where selective justice was the case. If you look across the jurisdiction now of the International Criminal Court, to be sure, it began with almost all situations that emerged from the African continent. Now, that was partly because those African states self-referred to the court. They reached out to the court and they said, we can't handle the degree of violence in our territory. We need the help of the international community. We need the help of the ICC. But if you looked at a map, it was primarily Africa-focused. That is very different now. We see the court active in Venezuela. We see the court focusing on the genocide against the Rohingya and the massive deportation of upwards of 1 million individuals to neighboring Bangladesh, which is an ICC state party. We see the court active in Georgia, in Ukraine. So it's now active globally. It's taking a much more global territorial approach. And so the argument that these institutions are focused only on the global south or only on Africa really doesn't hold sway when we look at the empirical matter, the empirical truth. All that said, these are valid arguments. We need to address them head on. We need to acknowledge them, and we need to look for ways to build bridges.
Right. I wanted to come back to the issue of the ICC and maybe reforming the Rome Statute a little later. But let's talk for a moment about the different models for a special tribunal. And you mentioned that the US wants I think you said a tribunal on the crime of aggression that is rooted in Ukraine's judicial system with some international elements. What's interesting is that I think President Zelensky is not such a big fan of this idea. And in his speech in The Hague, he said, and I'm quoting, that only one institution is capable of responding to the original crime, that's the crime of aggression, a tribunal. Not something hybrid that can formally close the topic, not some compromise that will allow politicians to say that the case is allegedly done, end of quote. So how do you convince him that your model is the right model?
Yeah, the other model that's being explored is something that would come through the General Assembly. Of course, the Security Council is completely foreclosed. Russia will, we can predict, exercise its veto against any measure that of any consequence against Russia. So the normal executive body within the UN Charter system, right or wrong, that's the system that we developed after World War II, and that's the system that we're stuck with at present. That gives Russia a veto. And so there's no place to go within the Security Council for a referral to the ICC or to create some sort of an ad hoc tribunal as was done for the former Yugoslavia and for Rwanda. So that has caused some states to think about, could the General Assembly do this? There are some legal concerns about that. The General Assembly under the UN Charter system only has the power to make recommendations. It does not have the power to take coercive measures. And so what would be the basis of jurisdiction of a tribunal that might be created by the General Assembly? It doesn't have the ability to exercise coercive powers. And so a defendant in custody would immediately challenge the formation of the tribunal and its ability to exercise jurisdiction over him. A tribunal, by contrast, that is based within the Ukrainian system, but with lots of international support, has the benefit of being international, of marshaling international resources, of marshaling international resources, of giving it the gravitas that I think Ukraine is looking for. Ukraine, understandably, does not want this to be a Ukrainian effort. It is not just the territory of Ukraine that has been flagrantly violated, but rather the entire system, and so this should be an international response. And so amongst the G7 and other states that also favor the idea of an internationalized tribunal as the most legitimate legally, we have to make concrete pledges to ensure that this institution has the resources, has the information, has the international support that Ukraine wants to see to have this be a truly international effort. So it's an ongoing conversation, and I think it helps that the Council of Europe and that other multilateral institutions are taking this on and trying to reach a common position.
Right. And, you know, there are downsides for all the different models. But the one thing that I wanted to ask you is related to the news that, you know, have been coming out of Ukraine very recently. And it's about, again, you know, the issue of corruption, which is really, unfortunately, Ukraine's internal enemy number one. And there were some very prominent corruption cases in Ukraine's judicial system as well. Is that a matter of concern for you, especially when you think about this model that is, like, you know, entrenched in the Ukrainian judicial system?
Of course, we're always concerned, I think all of us, about corruption. It has a major corrosive effect on the rule of law, on democratic institutions, and as you have said, Ukraine has struggled in this regard. Ukraine has also, I think, responded very strongly to these allegations. They have set up a focused unit. They have set up a special court system that has expertise in dealing with allegations of corruption, and they have started to root out corruption, including within their judiciary. And so it's, to a certain degree, a good news story. The system is working. They're able to identify and to respond strongly to any evidence that emerges of potential corruption within democratic institutions. But it's an issue that will need constant vigilance, and I know the international community is assisting greatly. We have our klepto-capture project within the United States that is working with their counterparts in Ukraine to strengthen the ability to identify corrupt acts and corrupt actors and to respond strongly against them with respect to law. It's also, I think, one of the rationales for doing an internationalized tribunal. This would involve the insertion of foreign judges, foreign experts, foreign prosecutors, foreign investigators, staff, into and sprinkled throughout this new imagined institution, and they would be then working side by side with their Ukrainian counterparts.
Which the Ukrainian constitution doesn't permit so far, right?
It does not permit at present, no. It would have to be, there would need to be some amendments to the local legal framework, but we've confronted that in the past with respect to the Special Tribunal for Lebanon, for example, or the extraordinary courts in the extraordinary chambers of the courts of Cambodia, the ECCC. So to be sure, there would need to be some amendments here, but you could also imagine judges and prosecutors playing an advisory role, which would not require necessarily any form of amendment. I leave that to the Ukrainian constitutional lawyers to determine. But the point of having international assistance working side by side has worked very well in other places like Bosnia, for example, where it's been helpful to have that international expertise, and then gradually you can sunset out the international involvement, and then you leave behind a stronger, fairer, more robust system with judges and prosecutors and investigators and defense counsel who've all had the benefit of working with international experts and can internalize those skills, those techniques, and then use them going forward to strengthen the whole judicial system.
Right. I want to sort of also reserve enough time for our guests to be able to chime in, but as we enter kind of the finishing line of this conversation, I also wanted to talk a little bit about the U.S. role in general when it comes to strengthening international criminal law. And I think, you know, all the work of your office and what has been coming out of Washington in general recently is very much appreciated. But again, as always, there is also criticism. And I've come across an interesting piece by a former colleague of yours, a professor of law at Yale University. Her name is Una Hathaway. And again, I'm quoting from what she wrote. She says that when the war, Russia's war of aggression against Ukraine, when the war began, after all, the United States had just recently lifted its unprecedented economic sanctions on ICC officials in retaliation for opening an investigation into possible war crimes by US troops in Afghanistan. Many looked on in disbelief as US politicians began singing the praises of that very same court and calling for Putin to be indicted, end of quote. Is that a criticism that you find fair, or how do you respond to that?
I think it's absolutely fair. And of course, as soon as the Biden-Harris administration entered, was entitled to change those sanctions, they did take them down. And Secretary Blinken has said that they should never have been imposed in the first place. That was definitely a new low point for the U.S.-ICC relationship. And so I'm extremely happy that this administration, prior to my taking this position, so we did not have an ambassador at large in position, a Senate-confirmed position, and that was done as a whole-of-government decision to bring down those sanctions, and of course that was an appropriate response. So now we are in a rebuilding phase. There has been a reset of the relationship between the United States and the ICC, and we are again recognizing that the ICC plays an important role within the whole international system of justice. It's not an exclusive institution. It depends very much on national courts being able to do most of the work themselves. this is the principle of complementarity, which undergirds the entire Rome Statute system, the Rome Statute being the treaty that created the ICC. And so my work as ambassador at large involves both supporting international institutions, trying to strengthen those institutions, ensuring that they have the resources, the evidence, et cetera, that they need, but also at the same time working to strengthen national systems. Because we know that ultimately the majority of cases will go forward before national courts. And so that is the obligation of states to take care of survivors and victims within their own jurisdiction and to deal with crimes committed on their own territory and by their own nationals. And so that needs to be the front line. And so it's a kind of a two-tiered approach. Strengthen the rule of law at a domestic level through our programming, our USAID, our human rights programming, our democracy work, and then at the same time, strengthening international institutions.
Right. I have one more $1 million question for you, Ambassador. When Annalena Baerbock, our foreign minister, went to The Hague, she delivered a speech, and in that speech she also said that she wants the restriction of the ICC's jurisdiction over the crime of aggression to be lifted. And she wants the Rome Statute to be reformed. Now, I understand that's really a big thing for the US when it comes to the ICC's assertion of jurisdiction over nationals of states that are not parties to the Rome Statute. That all sounds very technical, but maybe you can explain to us why this is such a big issue for Washington and why I think successive administrations have really had a hard time to agree to exactly this proposal.
Yeah, this has been one of the long-standing objections of the United States to the framework of the International Criminal Court. And the aggression amendments were drafted with a more limited jurisdictional regime associated with them. There were a number of states that agreed to that. That was a compromise that was made at Kampala back in 2010. The aggression amendments were finally activated in 2017, and that is the system. To be sure, we are now realizing the consequences of that system because the ICC has no jurisdiction over the crime of aggression because Russia is not a state party to the Rome Statute. And so the charges of aggression will have to be brought in this new separate institution. And so that has given rise to some proposals that we should revisit the Kampala amendments. I think the United States would oppose that in part because it was carefully negotiated already over many, many years. And to suddenly reopen that, it may be very difficult to reach another consensus, which we were able to reach back in Kampala. And so that's why the idea of creating a specialized, dedicated tribunal, the international community is also investing in an international center for the prosecution of aggression. This will be housed in The Hague as the Center for International Justice generally. And so there are ways around this jurisdictional gap that exists within the Rome Statute, and they're being activated here in the Ukraine context.
Very final question, Ambassador. What is the one most important step forward looking at the international legal system that you want to see accomplished by 2030?
Oh. I mean, I do honestly believe very strongly in the obligation of domestic states to address international crimes if and when they have jurisdiction. And so I would love to see states increasingly incorporate the prohibitions on international crimes into their domestic penal codes. The Clooney Foundation for Justice has recently launched a fascinating website. It's a sort of globe, and you can click on the different countries to show how they have integrated international crimes and the limitations, if any, on prosecuting those crimes. And so it's very helpful empirically to see what states are doing. There is a very now strong trend line towards states incorporating these crimes and then building in war crimes units, dedicated, specialized, expert war crimes units. We have one in our own system, they have one here in Germany and elsewhere. I think that is the new trend. Yes, international institutions will always play a role, but ultimately I think we want to empower domestic systems. But I would like to work even farther upstream. I think there's a lot more work that the international community can do and that international states can do around the imperative of prevention. Yes, we want to respond robustly to the commission of offenses, but wouldn't we all prefer to do more prevention work? And I've actually come here to Berlin from being in Warsaw, actually, where there was a meeting of like-minded states focused on trying to think about how to better coordinate our efforts to prevent atrocities. This involves everything from building more resilient systems elevating the voices of peacemakers, addressing hate speech and efforts to incite violence, strengthening domestic legal frameworks so that there is a deterrent impact of law locally, strengthening the ability to document crimes and call attention to abuses when they're happening. All of this is necessary so that ultimately we can prevent the kinds of crimes that now we have to only respond after the fact by way of prosecution. So to me, that's where I would love to see the international community making that robust commitment to prevention farther upstream, and doing that in a collective way through the United Nations and other multilateral configurations.
And we haven't even talked about Syria and other arenas, but maybe we can leave that to our conversation with our guests here in the audience. We have half an hour or so for you to chime in. Please briefly introduce yourselves, say who you are, say who you work with, and always remember that every question should end with a question mark. And Johannes van Arneveld is first.
I work in the German Parliament, but this question is more with a 40 years background as an active Amnesty member. I remember that in the early 2000s, actually with support by German MPs, we were trying to set up a kind of Russell tribunal, like a kind of mechanism with a view to the Chechnya war. It didn't in the end materialize. I don't have to go into detail. With a view to the current debate, why don't we consider doing that and allowing to develop all the legal arguments with a view to the crime of aggression, which I think have never been developed to that extent. And that's probably also one of the reasons why it's not in the ICC statute. And I think, frankly speaking, that would have deterred more of the P5 members of really subscribing to the Rome Statute. But is that a chance?
Johannes, please remember the question mark. Thank you.
It's a great question. There have been a number of these people's tribunals that have been convened, particularly for situations where there is some kind of entrenched impunity. So, for example, the so-called comfort women situation, there was a women's tribunal that was held that enabled survivors to come forward and to give their testimony. And a very experienced and well-respected panel of judges heard their testimony and issued an opinion, essentially, on the violations of international law that have happened. And this has happened in a number of other situations. There was, in fact, an effort to do this with respect to aggression. It didn't achieve a lot of international recognition, but it was a couple of months ago. My predecessor, actually, Stephen Rapp, who was the fifth or fourth ambassador at large for global criminal justice. I'm number 6. He was one of the prosecutors or maybe one of the judges. I forget what role he played. But there was an effort to say, look, we can do this. Here's the law. Here's the facts. Let's draft an indictment, a model indictment. Let's marshal all of this information. Let's identify what the elements are of a crime of aggression. Let's think about how we can match particular pieces of evidence to those elements. Let's show that it can be done. And we've seen this done by academics. You mentioned Ona Hathaway. She's been writing very strongly on this, showing, again, the pathways that it can be done. We've had several academics put forward model indictments that you could imagine being reworked and then ultimately issued in an actual court of law. So in general, I think these people's tribunals can be incredibly important in terms of focusing attention, but also providing survivors with an opportunity to bear witness. Mateusz mentioned this in his opening remarks. We tend to focus on criminal justice, but let's not forget that the toolkit of transitional justice is quite broad. It includes truth-telling. It includes memorialization, like we're seeing here. It includes lustration, right? Removing individuals from positions of power in a new regime so that they they're not in a position to represent the state going forward. All of this is part of a broad transitional justice approach, and I think Ukraine will have to think about how it wants to adapt some of these mechanisms and principles for its own system, even while it pursues criminal prosecutions.
Madam Ambassador?
Yeah. Please, go ahead.
Hi, my name is Brian Perlman, formerly of the UC Berkeley Human Rights Center, and I'm currently an OSINT open source intelligence investigator. With respect to the fourth pillar you mentioned, specifically the Justice for Victims of War Crimes Act that President Biden signed in January, in an ideal scenario, how would you like to see the DOJ implement this new law, in your opinion? And how do you think realistically they will implement it? And do you believe there's a possibility of bridging the gap between those two scenarios? And do you think the U.S. is closer to accepting universal jurisdiction, and do you believe the U.S. ever will? Thanks.
These were 4 questions in one.
It's okay. My answer will weave seamlessly between them because it's a consolidated answer. Thank you. Congratulations. Berkeley's work on open source investigations is really incredible, and they've issued the Berkeley Protocol, which sets sort of best practices for doing open source investigation, for verifying, et cetera. So it's wonderful that you had a chance to be a part of that program. So I want to emphasize that the United States already has universal jurisdiction on a number of crimes. It's a version of it because we require generally the presence of the accused. We cannot operate in an extraterritorial or in an in absentia fashion. And we cannot seek the extradition of someone if we're not able to immediately exercise or assert charges against them. So we need the presence. But our genocide law, our child soldiers law, our torture law, our series of trafficking statutes, our terrorism statutes, all of these allow for a form of universal jurisdiction. And what we did with this new war crimes statute is use the same formulation. So long as the defendant is present in the United States, our Department of Justice can proceed against them. So of course this depends upon perpetrators being in the United States. We are not likely to be a strong destination point of Russian perpetrators. Nonetheless, we know that people go where they can go. They go where they have family connections. They go where they want to go. They may have false identities. And so they may slip through the net and end up in the United States. We have a number of cases already moving forward. There's a case in Pennsylvania courts involving a U.S. person actually stands accused of committing torture. There's a case against a Gambian going forward in Colorado, also under our torture statute. So our Human Rights and Special Prosecutions Unit is starting to flex its muscles more when it comes to using the legal authorities it has when it identifies a perpetrator in our midst. We have had to, in a number of cases, utilize immigration remedies in the past. So with respect to Rwandan perpetrators who were found in the United States, our genocide statute was amended to allow for this present-in jurisdiction after the Rwandan genocide. And so there was ex post facto concerns there about prosecuting those individuals for genocide proper. So instead, what we prosecuted them for was immigration fraud. When individuals come into the United States, they have to make certain representations under oath that they did not participate in the persecution of others. These individuals checked the no box. That was proven to be a lie. We had to put on evidence of their involvement in genocide, so it's almost like a genocide trial. The final charge that they're convicted of is one of immigration fraud. Nonetheless, there are individuals serving very long sentences for these immigration fraud cases. And so that's the way we've approached this, given that our legal framework, we have ex post facto concerns and others. So I'm quite confident that the WARCAT, the War Crimes Accountability Team, is very keen to find cases that will fit within this new legal authorities that they've been given. I think realistically, just given the massive scope of war crimes in Ukraine, we are likely to pursue cases that have some kind of a U.S. nexus. Even though they don't have to, I just think as a function of sort of scarce resources, divisions of labor, where other states and institutions are already operating. And so I know that they're opening a number of investigations already. They're very close with the Prosecutor General in Ukraine. They have a memorandum of understanding with him so that they can share information. They're supporting the joint investigative team that some of the European states have created. So they're plugged into the system. And so they'll be in a position to be able to share and benefit from all of the work that's being done around the world around accountability.
Second question over here. The colleague in the second row. Yeah, the mic is coming.
Thank you, Madam Ambassador, for joining us. My name is Bogdan. I study international relations, and right now I'm on exchange in Humboldt University. My question will be short. Do you think how big will be a scale of people that are responsible for the fact of the Russian aggression, not for the war crimes that came after the aggression, but like for the fact of aggression itself? Thank you.
Yeah, it's really an excellent, very sophisticated question. Aggression historically has always been defined as a leadership crime. We saw this at Nuremberg. There are a series of verbs that are used within the Nuremberg Charter, so it's those who were designing, executing, etc., the war of aggression in World War II, and now the ICC statute definition is very similar in terms of those individuals who were in a position to design and implement a war of aggression. And so who is that? Well, okay, Putin, we can imagine. The foreign minister, minister of defense. How far down do you go? One can envision one layer of very senior generals and maybe a second layer. It's unclear. This is where we don't have a lot of precedent to work from. Interestingly, in the post-World War II period, there were a number of individuals who were acquitted for the crime of aggression, then called crimes against the peace, precisely because it was determined that they were not in a decision-making or executive position. That yes, they were involved in implementation, but at a very low level and not necessarily part of the apparatus of designing the war of aggression. And so we're going to have to look at that history and translate it into the current situation. That is precisely what this International Center for the Prosecution of Aggression that's being stood up in The Hague is going to do. They're going to figure out who within the political and military chain of command occupies that leadership level such that it would be appropriate to proceed against them, not for individual war crimes or other atrocities, but rather for being the architects of Russia's war of aggression. And so that's some of the work that can be done now while we continue to debate and discuss the modality for setting up a specialized tribunal of some sort to actually ultimately hear those charges.
And if I may, just a follow-on question, when we look at this hybrid model that the US proposes, the issue of personal immunities is not resolved yet, right? So how would you figure that one out?
Yes, there is this concept of head of state immunity, and it's enjoyed by the so-called troika, which is so interesting that it's the Russian word that we use, which of course predates the current crisis. Head of state, head of government, foreign ministry. These are individuals who, in a national court, under current law, would enjoy head of state immunity. Now, what's important about this is, number one, when they are no longer in those positions, that immunity dissipates. They only enjoy it while they're in power. And number two, there's nothing that prevents investigations of those individuals. Head of state immunity only kicks in when you're moving towards some sort of coercive measure, so issuing an arrest warrant and asking for it to be executed around the globe. That is when head of state immunity attaches. So even now, while Putin remains in powers, as does the rest of his troika, the International Center, domestic courts, etc., can all undertake investigations unhindered. They're just in a situation where they cannot yet press charges against those individuals at the domestic level. Now, there is a theory that international tribunals do not need to respect head of state immunity. There's some jurisprudence that suggests that, but it's never been tested with a live case. We've never had a case that has not involved the Security Council or the consent of the state in question for a sitting head of state being prosecuted for international crimes. So it's an open question, and I think there's some concern about testing that proposition, because are you not handing Putin a ready defense that he's entitled to head of state immunity? And so under any of the scenarios that are being considered, under any of the models, the reality is it's unlikely that they would be able to move forward against him until he's no longer head of state. Why? Because he's in custody, and he's not going to be in custody while he's a head of state. So either model presents this potential problem, and so it's a question of having the patience for when he's no longer entitled to assert head of state immunity.
Right. And we'll go to our next question. Sir, I think you wanted to come in. The mic is on its way.
Yes, thank you very much. Richard Herzinger, journalist in Berlin. My question is, what real capabilities has the UN to act against aggression and crimes against humanity if the perpetrator has a seat with veto rights in the Security Council of the UN? And do you see any chance at all to maybe remove Russia from this position? Thank you.
Yeah, as we've discussed a bit, Russia enjoys a permanent seat on the Security Council. The Security Council is the body within the UN Charter system that is capable of making executive decisions that can be imposed on other UN Charter member states. And Russia has exercised its veto with respect to a whole range of situations. You mentioned Syria. It protected its client state Syria from a number of proposals, including a referral to the ICC, sanctions, etc. And of course, it will exercise its veto to protect itself. That is the system we have. Right or wrong, that is the system that was negotiated at the end of World War II. We could not, if we were to dissolve the UN Charter system now, the United Nations, we couldn't create it again. That's the reality. We just could never reach a consensus to create a sort of a supranational body. And so we are in a position where we have to operate within the institutions that we have. Now, the situation of Russia utilizing its veto has inspired a number of kind of reform movements, some of which might require amendments to the UN Charter, which would require the consent of the P5, so that's somewhat of a dead end, but some of which don't. So there's various proposals for the permanent 5 members to pledge, for example, not to exercise their veto in the face of atrocity situations, or to explain why it is exercising its veto in order to show why important national security equities are implicated by a particular proposal and why the veto was being utilized. And I think those are extremely important for the international community to continue to discuss, so that when states utilize their veto, they're accountable for that veto. They have to explain why they're utilizing that veto, and there's maybe some consequences for utilizing that veto, especially when it's in respect to their own particular conduct. So these conversations are happening. Amending the UN Charter is extremely difficult, and I don't see that happening in the immediate future. I think this is the institution we have. We have to work within it. But we have also found really creative ways using regional bodies, regional configurations, et cetera, in order to make important progress outside of the UN system. And that's what we've had to do in this case.
Thank you so much. Oh, here's a question.
Hello, my name is Marielle Tierney, and I work with a volunteer organization called Berlin Arrival Support. Just to segue a little bit, we see how much disinformation and misinformation causes in the world, and I'm just wondering if you think AI poses a threat to the successful prosecution of these war criminals. Thank you.
It's such a great question. We do know that Russia has a unique ability to generate disinformation, misinformation, deep fakes, very credible deep fakes. This is absolutely something we need to be concerned with. At the same time, we should also recognize that AI is a potential tool for accountability. So we can train machines to go through hours and hours of video that would be incredibly traumatizing for a human being to go through, and to tag key videos, key images. We can do image recognition, we can do event recognition, we can do sound recognition. All of these tools can be marshaled in order to sift through the terabytes of digital imagery and potential evidence that are being generated by today's conflicts. So like any piece of technology, it can be used for good and it can be used for bad. And so what we need to do is strengthen our tools to be able to see the ways in which artificial intelligence, machine learning can be harnessed to create the kinds of deep fakes that we know can infect a justice system, but also teach machines to help us with our work around the accountability space. There's a conference happening next month in Costa Rica called RightsCon, and these are very much going to be the topics under discussion. And we'll be hosting my office a panel on this very question, actually, thinking about how to harness modern, new digital technologies, the fourth industrial revolution, in the service of justice and accountability.
Thank you for bringing that aspect into the conversation. Oh, yeah, sorry.
Yeah, thank you very much. Robert Sperfeld, working with the Heinrich Böll Foundation. One more question about the prosecution of the war for crime of aggression. If I understand it correctly, but correct me if I'm wrong, then this model of court to prosecute the Russian leadership is only individual prosecution of the leaders, in which circle. It's a different question, yeah. But how to make the Russian state also liable for paying damage and all what has happened, because I mean, yes, it's of course important that Putin and his clique is prosecuted, but of course we will also need a mechanism to make the Russian state pay for all the damage that is done. Is that part of these considerations, or which other formats would be needed for that? Thank you.
Yeah, it's a very good question. There are really two models of accountability. One is individual criminal responsibility. That was the concept that was sort of explored in the World War I period, never really came to fruition, although did to a certain limited degree, but that really flourished after World War II and created our system now of international criminal justice that's individual. Of course, though, we still have the concept of state responsibility under international law that has a much longer pedigree, in fact, at some level. And we have institutions that are capable of adjudicating state responsibility. Ukraine has been quite adept at utilizing lawfare in a whole range of institutions that have the ability to exercise state responsibility. So the Law of the Sea Tribunal, the Convention on the Elimination of Racial Discrimination, their claims under that treaty have been brought before the International Court of Justice, which has jurisdiction over states and not criminal jurisdiction over individuals. There is also a case under the Genocide Convention before the International Court of Justice, charging that Russia has misused the concept of genocide to justify launching this war of aggression. So there are a couple of fora around the globe that are looking at this question of state responsibility. But so many of these institutions are premised upon state consent. States have to consent to adjudication before these institutions. And Russia has simply not done that on a more general matter. And so adjudicating state responsibility for the war of aggression will be more difficult. In general, in national courts, states enjoy foreign sovereign immunity. We do have some exceptions within the United States, and other states as well have some exceptions in their foreign sovereign immunity statutes. And so it will be a question of whether or not any of those exceptions fit the bill here. They don't likely in the United States. I haven't looked at it closely, but there may be some exceptions in other states. And so this is a question, and this is why this Claims Commission is a really interesting proposal, but we're still working through the modalities of how to fund that commission. We know that billions of dollars in Russian assets, both private assets and sovereign assets, are subject to various freezes and sanctions around the world. And what are the legal pathways by which those assets can be liquidated and then put to the service of compensating Ukraine as it rebuilds after this war? And there are some difficulties under, I think, national laws, constitutional questions, due process questions, and there are some issues under international law, the protections against expropriations. And of course, anything that is done with respect to Russia could be done with respect to assets that are owned by the nationals of other states. And so we have to be very careful about creating a tit-for-tat sort of a situation. As we say in English, what's good for the goose is good for the gander. So I know some brilliant lawyers around the world are working hard at looking at what sort of nexus to criminal conduct will be necessary in order to be able to seize more permanently those assets and make them available for the incredible challenge of rebuilding Ukraine. And that's partly why we're creating a claims commission so that the architecture exists while we do the work of thinking about how to fund that. Now, if we get to a point where there's a new administration within Russia, they want to re-enter the international community. They want to acknowledge the harm that they caused. You could imagine voluntarily submitting to a claims commission process or some sort of an arbitral or a mediation process, as we've seen states do in the past. And so that is one pathway that might be available to us in the future.
5 minutes to go. I think we have time for one more question, if there is any.
Maybe someone from your Ukrainian community, or maybe może Państwo posłowie?
No, there is a raised hand over here. Well.
Hello, my name is Anna Isolova and I'm Ukrainian. First of all, I wanted to thank you, Madam Ambassador, for the important work that you do, especially about the abduction of kids that you're tracking this closely, because this basically prohibits Russia from rewriting history and creating tabula rasa that they've been trying to create for decades. But my question would be the following. Seeing that Russia, as a state from early 19th century, was run basically by same organization, all of their leaderships and ruler came from ČVK and KVD, KGB. So basically the structure that never was reformed and never was prosecuted. So the war in Ukraine, does it open the door for actually not individual prosecution, but for the prosecution of the organization all of those leaders and rulers came from, and unfolding it not concentrating only on the crimes committed in Ukraine, but unfolding it, to the Holocaust, to the concentration camp, and so on and so forth back into history. Thank you.
Yeah, it's an interesting question. After World War II, there was an experiment in organizational criminal liability. If you remember, the SS and some of the other organizations were indicted as organizations. And the idea was that individual members might then be found guilty by virtue of membership if it was shown that they knew of the agenda of the organization and participated actively in that. That experiment has not really carried forward. What we have used now instead is these sanctions regimes against entities that are associated with abuses. And so we've seen the international community respond with sanctions against some of these organizations. So it's hard to know whether we might return to that idea of organizational liability. At present, there isn't a pathway. The ICC only, for example, has jurisdiction over natural persons. There are some cases that are proceeding now in national courts around the world against corporations that have been involved in or complicit in or alleged to be responsible for international crimes. So in France, there's a case against Lafarge, which was a cement company that was active in northern Syria and was working with ISIL. And so the question is, can they be prosecuted for crimes against humanity by virtue of those acts in northern Syria? Those cases are proceeding, and so we should watch them closely and see what sort of precedent they might build. When it comes to more historical crimes, I think there's no question that what we are seeing happening in Ukraine is very similar to the type of conduct we've seen in earlier conflicts where Russia's troops have been involved. And Syria is a conflict that I've worked very closely on, and of course, Russia was supporting the Assad regime within his war against his own people within Syria. And so whether or not there will be a justice process focused on those more historical events, or simply the creation of information that we can use for truth-telling purposes, for memorialization, for potentially compensation and others, I think remains to be seen. But there's no question that we want to ultimately understand causes and consequences of Russia's conduct in the world. And the focus on Ukraine is going to keep the focus on these other situations and create, I think, globally a better understanding that historians and journalists and survivor communities all will benefit from.
Well, Ambassador, dear colleagues, it's 12:30. Our time is up, unfortunately. I think we could have gone on and on. Thank you very much for a super interesting conversation. Always daunting to interview a legal scholar when you're a non-legal person, but I learned a lot. Thank you very much also for the fantastic work that your office is doing. Thank you to our hosts here at the Pilecki-Institute, and also thank you to the American Embassy for making this possible. Thank you all, and I wish you all a good continuation of the day.
Thank you.